Well, I'm sorry, you're such a bad day, Lisa.
A person at the jail, please state your name for the record.
James Kevin Spencer Jr.
This, Mr. Spencer, I actually have two files for you. The first is an arraignment. That's the case of the people of the state of Michigan versus James Kevin Spencer Jr., case number 26-248ST. Have you had the opportunity to meet with somebody from the defender's office today?
Yes, sir.
And are you still on Shelby Street?
No, actually, I just moved back to Cadillac a week and 2 days ago. I was living down in Langsburg from May till now.
Okay, what's a good mailing address for you?
It's 309 West.
What's your telephone number?
It's actually my fiance's telephone number. It's 231-429-4769.
In the city of Manton of Wexford County, it's alleged that you committed the offense in count number 1 of driving while your license was suspended, denied, or revoked as a second or subsequent offender. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000 and possible vehicle immobilization. In count number 2, it's alleged that you committed the offense of operating without security or insurance. That also is a misdemeanor punishable by not more than 1 year in jail and or a fine of not less than $200 nor more than $500. Do you understand those charges and the potential penalties?
Yes, sir, I do.
Did you read and sign an advice of rights form there at the jail? Talk about your rights to an attorney and your rights to a trial?
No, they never gave me one.
Did you read it?
I never got one, but I know what they are.
Oh, you never got one. I'm sorry. I thought you said you'd gotten one. So I know you probably know these, but I have to go through them with you. So if you require accommodations to use a court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make those arrangements. You've been brought to court on a misdemeanor charge, and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered, and you may plead no contest with the permission of the court. To have a trial by jury and to the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money to hire an attorney. And if the offense charge requires a minimum jail sentence, or the court determines that it might sentence you to jail, the appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any cost for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. To be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind. You'll be giving up those trial rights that we just went through. You also have the right to be released on bond, and we'll get to that in a moment. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court may be taken within 21 days from the date of sentence, or is permitted pursuant to court rule if the sentence includes incarceration. And if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days after sentencing. Federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are a former or current spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Mr. Spencer, do you understand those rights?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I mean, I don't wanna waste the court's time on it, you know what I mean? I don't wanna be in jail.
Well, you're not
for
wasting our
driving.
time because
I
we're
wanna
here
be
all the
home with my
time.
kids. I know. I just got custody of my kids last April. I'm trying to get all this loose end stuff taken care of, all my fines, you know what I mean?
I do. So do you want the court to put in a referral for an attorney, or do you want to represent yourself?
I'll just do it myself.
You're gonna do it yourself?
Yeah, I guess.
All right. Today, you have a couple options available to you. One is to plead guilty. If you pled guilty as charged, the 2 misdemeanors would enter on your record and we would sentence today. The other is to plead not guilty. If you pled not guilty, we would set the matter for a pretrial, which would give you the opportunity to discuss the case with the prosecutor to see if there's a way to resolve it short of trial or plea as charged. So today, do you plead guilty or not guilty?
I'm gonna do not guilty for now.
All right, the court will enter the not guilty plea. We'll set that matter for a pretrial, and that gets us to bond. You do have the right to have a bond set. Bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Ms. Dull, any comment regarding bond?
Your Honor, just that Mr. Spencer has a very long criminal history, including multiple driving offenses, multiple assaultive offensive. I believe some bond would be appropriate considering his criminal history and his many driving offenses. And he knew better. He has had multiple operating while intoxicated offenses. He had multiple driving while license suspended. He knew not to drive. So I believe he does pose a risk to the community. So that is the people's request.
Do you know what brought him to the attention of law enforcement?
I slid through a stop sign.
Oh. Okay.
That is correct. He did drive through a stop sign without stopping.
All right. Mr. Spencer, you're also here on a bench warrant for fail to appear for a financial review hearing back on July 31st. And my staff has in the notes that they talked to you on the 29th and that you said you would appear. Why did you not appear for that financial review hearing?
I never talked to anybody. I've been down in Lynchburg since May. I didn't even know nothing about any of this. I mean, I'm not gonna run from a financial review, you know what I mean?
Yeah.
I've been living down at 302 High Street in Lynchburg since May until just a week and 2 days ago.
All right. The court
So
is
if you
familiar
talk to
with,
anybody, it was probably my dad or somebody that lives at my dad's house that worked that 610 North Shelby Street.
all right. I don't know. All I know is that the notes indicate that they spoke with defendant and will appear for court. However, I will say that I am familiar with Mr. Spencer and I've not had, not that I can recall any failed to appears.
Yeah, I'm not gonna
So the court will go ahead and authorize a person recognizance bond. Mr. Spencer, you are to appear as ordered, to keep your contact information current, not leave the state without permission, and to commit no new crimes. We will go ahead and reset the financial review hearing. Make some notes. Well, I guess first, let me ask you, it looks like you currently owe the court $6,813. Are you able to make any payments on that?
I'm not gonna be able to today, but I probably can bring like $50 by like Friday or the 1st.
Are you able to commit to any type of monthly payment on it?
I can do at least 50 a month.
You
For
sure
now.
you can do the 50 a month?
Absolutely.
All right, so what I'll do is I will do $50 a month. And I'm gonna make your first payment due. I'm gonna make it due February 2nd.
All right.
Can you do that?
Yes, sir.
It's next Monday.
Yep.
And then we'll do the first of the month thereafter, and we're gonna reset it for a financial review hearing in 3 months. If you're keeping up with those payments, you'll be good. If something happens that you can't make a payment, let us know. Don't just ignore it. We'll work
All
with
right.
you as long as you work with us.
Oh, I know.
Before you leave, Before you leave the jail today, you'll receive both of your next court dates. All right.
All right. All right, thank you.
All right. Thank you. Next arraignment jail. All right. Court calls the people of the state of Michigan versus Matthew Ryan Morris, case number 253695 FY. Appearances, counsel.
Joanne and Carrie for the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Morris.
We are here after having received a report from the State of Michigan Department of Health and Human Services Center for Forensic Psychiatry. Sorry. Have both counsel received a copy of that report dated January 15th?
I have.
I have as well, Your Honor.
And so we're here for a competency determination. It appears that Mr. Morris is now competent to stand trial. Mr. Harrison?
Well, that definitely is the conclusion that I drew after. It's a rather lengthy letter for what it's worth, Your Honor. This is more than the average sort of report that we usually get. I believe the conclusions that they've drawn in there appear to be accurate. And at this point, we don't have any reservation or any glaring need to have a separate evaluation done. We, I guess, should reserve the right to do that, but at this point, we're comfortable with the competency of it. Terminology is used in this letter.
All right. Mr. Morris, I should have asked, I know you're at the jail and appearing by Zoom. Are you able to see and hear us?
Yes.
All right. Ms. Carey, your take on the results of the report?
Well, at this point, after I thought it was an interesting report, but I will follow what they recommend.
All right. All right. Based on that, then the court does find Mr. Morris competent in this file. This will get put back on the docket. Let's sign the order. All right, Mr. Morris, you may be back in a little bit to talk with Mr. Harrison, but for right now, you'll need to go with the corrections, all right? All right, court calls the people of the state of Michigan versus Matthew Ryan Morris, case number 24-3329 SM. Appearances, counsel.
Please sit all for the people covering for Ms. Carey.
I'm Jeff Harrison. I'm here on behalf of Mr. Morris today.
And on this case, we're here for another competency examination. We didn't deal with it on the last case because the court had a conflict because I was the elected prosecutor when this case had arose. However, Mr. Harrison, have you had the opportunity to discuss that issue with your client?
We have indeed, Your Honor. He has no issue waiving that conflict, or as I explained to him, to simply allow you to hear the case as the judge.
Mr. Morris, did you have the enough of an opportunity to discuss that potential conflict with Mr. Harrison?
Yes.
And are you comfortable in me proceeding as the judge?
Yes.
All right. Then based on that, then I will, is that the waiver, Mr. Harrison?
That's the waiver, yeah.
I'll sign that
Chief
once I
Deputy
receive it.
Clerk Ms. Golnick handed it to me.
Can I have a copy of this report?
Make a copy for that one.
All right, we are here for competency examination on this case. The court has received the report from the Department of Health and Human Services Center for Forensic Psychiatry dated January 15th, 2026. Counsel, have you both received that?
Yes.
Your Honor, I did not, but Ms. Carey did, and I did speak to her about this case.
Okay, all right, thank you. Mr. Harrison, I'll leave it to you then. Where are we at?
I have spoken now with Mr. Morris about this. He did express his support for the conclusion that he was competent to stand trial, so that's as far, frankly, as we can probably go today. I do express even some reservations, and after having spoken to him, and also with some of the language in the memo itself, or the letter itself, which indicates we may need an independent evaluation here. I don't know that right now as we sit here, but I'd like to at least have an opportunity to raise that issue in the future.
All right. Ms. Dole?
Your Honor, after speaking to Ms. Carey, or communicating with Ms. Carey, the board's position is that we will support the recommendation of the
Mr. Harrison, we know competency can be raised at any time, but
Right.
you're asking to reserve for an independent evaluation. How long do you think you'll need to make that determination?
Oh, inside of a week. The only reason I'm hedging my bet a little bit here is that this is now the third attorney that's been on the file, that being me.
Mhm.
And I'd like the opportunity, Mr. Hartel has had much more prior contact with Mr. Morris. And I'd like to at least give him the opportunity to weigh in on this. It's just a scheduling thing that happened today. I'm up to speed as far as that goes. I've read the documentation from the forensic center, but that, I have reason to believe that that may not be telling me the whole story.
So just for the record, because it looks like Ms. Fiorvento is the last attorney of record, are you handling it just for today's purposes?
Just for today is my understanding. It's been an odd week on a number of fronts.
Sure.
There was a trial that was actually scheduled to begin today, which isn't conventional, in circuit court, in which Anna was participating. That case was resolved with a guilty plea about 10 o'clock this morning. So we shuffled the deck to send Mr. Hartel to Misaki for their arraignments in anticipation of her absence, which didn't occur. So I'm not 100% certain what the future's going to hold here, and I don't want to leave Mr. Morris paying the ultimate price for us not being able to schedule his attorney to be here with him today.
What I'm gonna do, we've met within the 5 days, which is required by the court rules. I think we've met that requirement. What I'm going to do is I'm going to reschedule this then for continuation on the 3rd.
Okay,
And during that time, that will give you time to decide whether or not you're going to agree with the recommendation or if you're going to request your own evaluation to be done. Anything else for the record?
nothing, Your Honor. Thank you for that accommodation.
No, Your Honor.
Thank you, Jail.